Good morning. The Securities Litigation Committee meeting is now being recorded for record-keeping purposes. By participating in this session, you are consenting to the recording, retention, and future viewing of this meeting. This meeting is now being live-streamed. Thank you.
Okay, good morning. The hour of 10:05 having arrived, I'd like to call the February 24th, 2021 meeting of the Security Litigations Committee to order. I'd like to welcome my fellow committee members, Senator Vince Hughes and Ms. Marchowski, his designee, as well as our newest member, Representative Paul Schemmel. May we have a roll call to establish a quorum, please?
Senator Hughes.
Tony Marchowski here for Senator Hughes, present.
Good morning, Ms. Marchowski. Mr. Jordan?
Here.
Representative Schemmel?
Here.
Thank you.
Thank you very much. Before we get started with today's agenda, I'd like to announce that there has been an addition to the agenda. At the conclusion of the published agenda, we will be going into executive session to discuss a potential litigation matter with counsel. After coming out of the executive session, there may be a motion in the public session. And with that piece of housekeeping being done, I guess the next order of business is to hand the meeting over to Terry Sanchez, our Executive Director for the election of the committee chair.
Thank you, Mr. Jordan. Nominations are now in order for the office of committee chair for the Securities Litigation Committee. May I have a nomination for chair, please?
On behalf of Senator Hughes, we would like to nominate Greg Jordan to resume his position as chair of the committee.
Thank you very much. We have Mr. Jordan. Are there any other nominations? Hearing none, all those in favor of Mr. Jordan for chair of the Securities Litigation Committee, say aye.
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 Opposed, no. The ayes have it, and Mr. Jordan, you are the chair of the Securities Litigation once again, and thank you very much for your service.
Thank you.
May continue.
Thank you to my fellow board members for nominating me and electing me as chairman once again. The next order of business is the approval of the minutes of the September 29th, 2020 Security Litigations Committee meeting, and a motion is in order to approve the meeting minutes of the September 29th, 2020 Securities Litigation Committee meeting. May I have a motion?
Moved.
Second? Okay, having a motion and a second, the approval of the meeting minutes is before us. All those in favor say aye.
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 Opposed, nay. Okay, the meeting minutes from the September 29th, 2020 Securities Litigation Committee meeting are approved. Next order of business is the old business, and under this category we have an update on the establishment of the Securities Litigation Pool, which is a joint effort with our sister agency PSERS, and Mr. Chris Houston is going to discuss this for us. Chris?
Yes, thank you very much. Before I start, I just wanted to introduce Britt Ernie. She was so kind as to do roll call, and she'll be doing the roll calls today. Britt is an attorney in the Chief Counsel's office, and going forward, she will be staffing this committee for future meetings with my new responsibilities and duties. Britt will be ably taking on those responsibilities. So what I would like to do is just provide a brief update on, as we had reported to you in the past, working with the PSER's legal office on establishing a securities litigation pool. When we became independent, our legal office became independent, we determined and included in the third amended securities litigation policy the fact that this board or that our board would work in conjunction with PSERS in the establishment of a new pool. Up until we became independent, we were using a pool of firms that was established through a process through the Office of General Counsel. And we can currently access that pool, but we wanted to create our new separate pool specific for our purposes because of our independent status. So we've been working diligently with the PSERS legal office to create a pool, which is a pool of qualified law firms to serve as securities litigation counsel for the board. Very briefly, the process, the way it's going to work, is we worked on finalizing a request, what we call a request for qualifications, which we plan on issuing here sometime in March, whereby firms will be requesting a statement of qualifications. We're going to have about a 6-week period within which to respond to this, we'll call the RFQ. There are minimum qualifications that we have worked out with PSERS that firms have to meet to be able to be a member of the pool. Once they're in the pool, their commencement in the pool, I should say, would commence upon their agreement in principle to the form of legal services contracts that are attached to the RFQ. And the way it works then for purposes of securing counsel on any particular matter is each board, or they could issue it jointly, would issue a request for proposals to members in the pool, to which they would have to respond by providing specific qualifications pertinent to the matter in question. And so these would be typically matters where we would be seeking lead plaintiff status in a class action litigation matter. And the specific qualifications would ask for their particular technical expertise and other factors relevant to the particular case at hand. And they would also identify their cost matrix as to how the fees would be earned by them. In these types of matters, just so you're aware, there's no fee paid by the agencies. It's sort of a contingent fee basis, if you will, based on whether they prevail in the case. And all of that would be established at the time that the RFPs would be reviewed and for purposes of selecting a firm. Typically, securities litigation cases, there's a very, very, very small window of time within which you have to select counsel to be the lead plaintiff. So it would be which is one of the purposes of establishing this pool, is that these firms would be able to quickly respond to an RFP. We would quickly be able to score the RFP and then identify the firm that we would be engaging with. We have worked out with Department of General Services the new goal setting provisions, so the firms will be advised, and when I say goal setting, this is for small diverse business and veteran business enterprise participation, and all these firms are being advised up front now in the RFQ that for specific matters that these requirements may be included when the RFPs are issued. So as I said, we're hoping to have the RFQ issued here sometime in March, and then hope to have the pool finalized after at least a 6-week period after we get the responses, and then so it'll be a couple months though before we have the pool established. So I just wanted to provide that brief update and be happy to answer any questions on this, and we're very, very happy to be working in conjunction with PSERS on this. It's been working very well. And we again are glad that we're able to do this type of a matter jointly with them. Any questions?
Okay, thank you very much, Chris.
Thank you.
Moving on to new business. The first agenda item under new business is the appointment of the assistant chair. And I would like to appoint Senator Vincent Hughes to serve as the assistant chair of the Securities Litigation Committee. As many as are in favor of consenting to the appointment of Senator Hughes, say aye. 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 Those opposed, no. The ayes have it, and the appointment of Senator Hughes is confirmed. Thank you very much for that, Senator Hughes. I look forward to working with you in the next year. Okay, that being done, the next agenda item is the Securities Litigation Committee work plan, and I believe, Chris, you're going to review that for us?
Yes, I will. Thank you. So in your Board Docs materials under item 6B, there is a Securities Litigation Committee work plan. There's not a lot on it because there's really only a couple of matters that are sort of routine in nature. One is the biennial review of the charter, which is the next item on the agenda. And then we will, though, this September, doing our biennial review of the securities litigation policy. The policy provides, and the charter provides that we do a review of that every 2 years. So that will be coming up later this fall. Other than that, there are no other anticipated regular work items for this committee. And typically the committee is only called when needed. It doesn't have the regular schedule that many of the other committees have. So unless you have any questions about the work plan, that's what I have for that item.
No, it's fairly brief and straightforward, so thank you for that. That brings us to the discussion of the securities litigation charter review. It appears that most of these changes are technical updates and conforming updates. So, Chris, if you could take us through that, I'd appreciate it.
Sure, happy to. So again, in your board docs under 6C, you have a red line of the committee charter. And as Greg pointed out, essentially they're sort of very technical in nature to deal with such things as renaming of the Office of Chief Counsel to the Chief Counsel's Office based on a reorganization, and some other very minor technical changes. It's a two-step process for the charter review. The charter provides that every 2 years the committee is supposed to review the charter and make any suggested changes to the board. However, the Board Governance and Personnel Committee also has a role in this review process. So all of the committee charters from all the committees are then presented to the Board Governance Committee for their review and hopefully concurrence with the proposed recommended changes. We anticipate that occurring at the April Board Governance Committee meeting. So all of the charter revisions would then be packaged, if you will, for the meeting. We do have an action item on the agenda, though, to move the charter, if you will, to the next step. So that's what I have to offer, and unless anybody has any questions, Greg, I think you're all teed up to take action on that.
Yes, if does any of the other committee members have any questions about the changes to the charter? Hearing none, a motion is in order for the Securities Litigation Committee to recommend 1 to the State Employees Retirement Board Sorry about that. Let me start over. A motion is in order for the Securities Litigation Committee to recommend, 1, to the State Employees Retirement Board that it approve the amendments to the Securities Litigation Committee Charter as set forth in the attached, after receiving input from the Board Governance and Personnel Committee, and 2, to the Board Governance and Personnel Committee that it concurs with this committee's recommendation and so inform the Senate or the State Employees Retirement Board. May I have a motion, please?
Moved.
Second?
Seconded.
Okay. The motion has been properly moved and seconded. All those in favor say aye.
This will require roll call.
Oh, I'm sorry. Britt, may we have a roll call then?
Yes, sir. Ms. Markowski on behalf of Senator Hughes.
Aye.
Chair Jordan.
Aye.
Representative Schemmel.
Aye.
Thank you.
Thank you, Britt. The vote was unanimous and the motion is approved. Thank you.
Thank you very much.
Okay, the next item on the agenda is the update on the Porsche and Volkswagen litigation cases, and I believe Mr. McCormick's going to lead this discussion.
Yes, thank you, Mr. Chair. Good morning to the committee members. My name is Jeff McCormick. I am the Deputy Chief Counsel on the business and transactions side of the SIRS Chief Counsel's Office, and I'm also counsel to the Securities Litigation Committee. Let me start by giving a brief background about the Volkswagen and Porsche cases. In September of 2017, SIRS registered its claims in 2 separate group litigations in Germany, one against Volkswagen in Braunschweig District Court, and the other against Porsche in Stuttgart District Court. The actions were based on the fraudulent actions of Volkswagen AG, the parent company of Porsche, for installing so-called defeat devices in their vehicles aimed at manipulating emissions testing of millions of vehicles sold worldwide. Within 2 days following the revelations to the public of this omissions software manipulation, the stock price dropped 30% and continued to plunge. SIRS's damages estimates were well above the threshold for joining a group litigation such as this in a foreign jurisdiction. And so we registered, and we are represented by the law firm of Robbins Geller, which is a firm that's was then and is currently in OGC's pre-qualified securities litigation outside counsel pool. As Chris alluded to earlier, we'll have our own pool established within a few months. The update is a brief one and is really more towards the Porsche case, and I think it's good news. In that case, about 6 to 8 months ago, the court started awarding damages in favor of our group and was going down the list one by one, entering judgments in favor. Porsche appealed to stop that. Our group appealed also to make the awards bigger. Fast forward 6 months, and now the current update is that we won the appeal, and the damages will be assessed on the 2009 to 2015 fraud portion of the damages at 19, I believe it's 19,000 euros per share, which they categorize as a very big win. We will, they're having a finance expert review the client's investments and calculating damages for everybody in our litigation group, which they estimate would take another 6 months. But they seem to think that this is a very big award. So that is categorized again as a big win. The other thing that came out of that successful appeal is that the higher court finally named a model claimant, which in Germany is sort of equal to like a lead plaintiff in a domestic action. And the lead plaintiff that was named is one of the clients in our litigation group. It's Wolverhampton City Council from the UK. So essentially our litigation group has been named model plaintiff, model claimant, and so we now officially have a seat at the table. Our counsel will be able to be directly involved in all negotiations for settlement and things like that going forward. So again, two big wins for us in the Stuttgart, Germany case against Porsche. Any questions?
Okay. Thank you, Jeff. That's very good news indeed that that case is moving forward in a manner favorable to the fund. We have two more items under the category of new business, the class action receipts for the third quarter and then the 2020 Securities Litigation Annual Report. And I believe, Jeff, you're going to discuss those. Is that correct?
Absolutely.
Okay. Thank you.
If you look on agenda item 6E, you'll see the class action receipts. I believe in the September meeting we had reported on the first half, which I believe is, quarter 1 and 2, which is there in your executive content tabs. And we have received newly for this meeting the class action receipts for the third quarter of 2020. You can see they were fairly low. Most of it coming from the one case. And it's the total is about $44,000. So the third quarter didn't produce much. Again, this is basically a list that we get from our custodial bank, BNY Mellon, who files proof of claims on CER's behalf in all domestic cases. When there are notices of settlement in cases, we will get a notice from BNY Mellon letting us know that there's been a settlement and that they will file proofs of claim on our behalf unless we notify them, before the deadline that we would like to opt out of the class and bring our own action. The damages have to be above $7.5 million for us to even contemplate opting out of a settlement of the class action when we're a passive member of the class, and that's a rarity. So in most cases, such as these listed here, and in the cases as well that are listed in the first two quarters reports for 2020, BNY Mellon simply files proofs of claim on our behalf, and the proceeds come in as our pro rata share. The pro rata share will always differ depending on various factors, from how many claimants file proofs of claim, obviously what the final settlement number is, and then depending on how many shares that were sold and the damages that are calculated, that's how these settlement proceeds are decided. So are there any questions with regard to the settlement proceeds for the third quarter of 2020? Okay, thank you.
Thank you, Jeff. Do you want to move on to the annual report then?
Sure. In item 6F of the agenda, we have the Securities Litigation Monitoring Report. We have several on here. I believe we were doing, that's annual. Okay. So as the annual report, we basically got them split up here by quarter. If you open up the first quarter, you will see that basically how we do these reports is that we list by month the inquiries that we receive from various law firms and other sources. Sometimes it's one of our investment managers that might alert us to a case that's been filed. There are securities litigation law firms that, it's basically their job, it's their lifeblood to be monitoring whenever one of these cases are filed domestically, anywhere in the country. It's filed usually by the initial plaintiff, but then once it's filed, there are 60 days in which any plaintiff, that qualifies as a plaintiff, and that is if you held the securities that are the subject of the litigation during the established class period, then you qualify as a plaintiff. And plaintiffs can then file an application with the court to become the lead plaintiff, and then also select lead counsel on behalf of the plaintiff investors class. So these reports are designed to show the board and the committee that of the cases that come our way, and we are asked to make inquiry of as per the process established by the securities litigation policy. You can see on the far right that there are 3 thresholds that we're looking at, and those thresholds are dependent, they reference 3 separate situations in which SIRS might get directly involved with a case. The first one is at the outset of a domestic case. We have a $10 million damages estimate threshold for SIRS to even begin to evaluate whether or not it wants to get involved. If it does, again, we would get, there would be a full analysis of the damages, the collectability of the damages, the merits of the case against the defendant. It would go through a process where we would get we'd get advice from a consultant or from law firms in the pool as to those items, and then based on that, the Securities Litigation Committee would vote to go forward. We then would go through the hiring process of getting counsel, which, as Chris alluded to earlier, we would issue an RFP to the pool in order to get a winning law firm that would then represent us in the case, and then an application to become lead plaintiff would come after that. So it all has to be within the first 60 days of the case, and it has to be at least $10 million in damages that we're showing for that evaluation process to even begin. The second is also in a domestic case, but it's at the end of the case. It's when the case has been settled. That's after lead plaintiff has been established, motions to dismiss have been gotten passed, the class has been certified, usually there's been some discovery, and then at some point these cases always seem to settle. That's when we get the notifications. Again, on a domestic case, we get notifications from BNY Mellon letting us know there's been a settlement, and then there's usually a few months lead time if a member of the passive class, so not the lead plaintiff, doesn't like the settlement, thinks it can do better on its own, it can opt out of the class and the settlement, and it can bring its own claims in a separate case. For us to evaluate whether or not we would want to opt out, the damages have to be above $7.5 million. Finally, the third situation is in a foreign or international jurisdiction case like the VW and Porsche cases. That's a much lower threshold of $1 million for us to have further evaluation for joining a litigation group, and that is because in non-domestic cases, in order for SIRS to receive any of the award when it's been damaged in a group securities litigation matter outside the United States, is that they have to actively join a case at the outset. If they don't actively join, if plaintiffs don't actively join a case, then you forfeit your claims, which is the opposite in domestic cases where you're considered to be per se a part of the passive class, up until you're given a notification of a settlement, and then you have to file your proof of claim in order to get the award. So that's why the threshold is lower, because there isn't sort of a per se membership to the class like there is domestically.
Okay,
so
Jeff, I think that's a great overview. I think maybe we could just ask if anybody had any questions about those, because I think we do have to move on to the executive session items. So.
Gotcha. So that's giving some background. I know there's some new members to the committee. That's what those thresholds are in the upper right-hand corner. You can see that the recognized losses on these reports were well below the thresholds, and that's why we didn't come to the committee in 2020 with an opportunity for further evaluation in any of those situations. Are there any questions about these reports?
Okay, thank you, Jeff.
Thank you.
Chris, do you want to go into executive session now?
I think now is the appropriate time that we would want to do that, and I think Jeff is going to make an announcement about that.
Okay.
Yes. As per the Sunshine Act, at this point of the meeting, the committee is scheduled to discuss a potential litigation matter with counsel that will include confidential and attorney-client privileged communications, and thus is appropriate for executive session.
So let's wait for our signal from Alan.
You're good to go, sir.
Okay, thank you. Okay, having completed the executive session, we are back in regular session. We discussed a potential securities litigation matter, and a motion is in order to authorize the executive director, chief investment officer, and chief counsel of the Pennsylvania State Employees Retirement System to 1. Determine if it is in the best interest of the system and its members to support or be a signatory on an amicus curiae brief to be filed by Kessler, Topaz, Metzler, and Check, LLP, in the United States Supreme Court in the case of Goldman Sachs Group Incorporated versus Arkansas Teachers Retirement System, number 20-222, supporting the Arkansas Teacher Retirement System. 2, seek any other delegations or approvals necessary from the Office of Attorney General to support or sign the amicus curiae brief. And 3, take any steps or actions, grant any approvals, or make any signatures necessary to express and effectuate the Pennsylvania State Employees Retirement System's amicus curiae support of the Arkansas system retirement. May I have a motion, please?
Move.
So moved. Second?
Seconded.
Okay, the motion has been properly moved and seconded. Britt, may we have a roll call?
Yes, sir. Ms. Markowski on behalf of Senator Hughes.
Aye.
Chair Jordan.
Aye.
Representative Shimon.
Aye.
Thank you.
Okay, the ayes have it, and the motion is approved. The next order of business is committee comments and concerns. Do any of members of the committee have anything they'd like to discuss at this point? Okay, hearing no committee questions or concerns, a motion to adjourn is in order. May I have a motion, please?
So moved.
Okay. The motion to adjourn has been moved and seconded. All those in favor say aye.
Aye.
Aye. Okay. Thank you very much. The Securities Litigation Committee meeting is adjourned.